When buying a business, the concept of caveat emptor applies, which means let the buyer beware. In short, this means that the buyer of their business is responsible for finding out if there are any issues with the target business. It is not completely on the seller to voluntarily tell the buyer of such issues. And that is why due diligence before you buy that business is extremely important. For this, in this video, we'll be discussing the top 3 things that may come up during your legal due diligence when buying a business here in the UK. If you're new, let me very quickly introduce myself. I'm Malcolm Zoppi, an English qualified solicitor and the managing director of Zoppi, my law firm. And my goal on YouTube is to make business and acquisitions easy. Make sure to stay until the end of the video to find out how to use heads of terms to your advantage as the buyer. Great, let's jump straight into it. So what is due diligence? Due diligence is the process that the buyer usually takes to find out if there are any issues with the target business. During that process, the buyer will be investigating the business by, for example, reviewing documents and checking contracts. So how are the results of your legal due diligence used? There are 3 main ways in which you can use these results. Number 1, you can use them to actually decide whether buying that business is a good idea or not. The second main way is to use that information to reduce the purchase price via negotiations. And the third way is to use that potential red flags to protect yourself by including in your sale and purchase agreement both indemnities and warranties. Just to very quickly define indemnities and warranties. Indemnities in this case would make the seller have to pay you if a specified issue arises. And warranties are promises as to the state of the business. Amazing. So now let's move on to the top 3 legal issues you might identify during your legal due diligence. Issue number 1 that you should always check for, and sometimes people take for granted, is to ensure that the seller is actually the seller and actually is able to sell you what they're looking to sell. So let me explain. In share purchases, you'll be buying the shares of their business. And that means that the seller should be the full legal and beneficial owner of those shares. Evidence of ownership of those shares should come in 2 main ways. Number 1, you should ask the seller to give you a copy of their share certificates. The share certificates should state the amount of shares that they own and who actually owns them. Those names must match with the person that you're looking to buy the shares from. And secondly, you'll be wanting to ask the target company to share their statutory registers with you, which are like spreadsheets, and you want to check the register of members to ensure that the seller is recorded as the owner of those shares. When it comes to asset purchases, make sure to keep in mind that the seller is not the individual behind the business. It is the business itself that is selling you some of its assets. And additionally, you want to ensure that the seller actually has the right to sell you those assets, which we'll be discussing right now. Issue number 2 is provisions in the contracts between the target business and, for example, customers and suppliers. With an asset purchase, you'll want to ensure that the seller, the business, has what is called a right to assign their rights and obligations to a third party. If there isn't such a specific provision in the contracts between the target business and their customers or suppliers, then they might not be able to sell you those assets. And even if you buy them or try to buy them, that acquisition might be recognized as legally invalid. Instead, if you're doing a share purchase acquisition, you'll want to look out for change of control provisions. Change of control provisions give, for example, the customers and important suppliers of the target business the right to terminate their contract with the target business if there is a change of control. Now, typically, change of control is defined as more than 50% of the voting shares of that company are sold to a third party, for example, yourself. Since we should at least safely try to assume that if you do buy the shares of that business, it will be recognized as a change of control, you want to ensure that the important customers and suppliers that you want to keep with the target business do not have the right to end the contract if there is a change of control. Because if that were the case, the moment that you buy their business, it decreases in value because it's possible that customers and suppliers terminate their contracts. Now, before we move on to discussing the third and last red flag that might come up in your legal due diligence, make sure to subscribe to my channel because it will continue to give you to the point, pragmatic and practical legal information and templates. On the topic of templates, I've linked in the description below a template legal due diligence questionnaire that you can freely download right now. Also, if you want professional legal advice and assistance from a qualified solicitor when it comes to your business acquisition, make sure to reach out. I have my details linked in the description below. Now, the third main risk actually relates to intellectual property. Now, sometimes businesses separate their intellectual property and place it in a third entity, in a separate entity. I actually tend to advise my clients to do so because the separate entity will hold the important assets of your business, the brand, whilst the separate entity, the trading company, will conduct the business. And what you want to avoid is trading co being involved in terrible litigation, ending up in liquidation, and you lose all of your intellectual property. So this means that when conducting legal due diligence, you'll want to check the government's website, the Intellectual Property Office's website, to check for the ownership of the trademarks of their business. If the trademarks are owned by a separate entity, you'll want to ensure that when buying the business, you also enter into a separate contract with the relevant entity that owns those trademarks to buy them from them. So for example, if it is trademarks, you'll want to enter into a trademark assignment agreement. Amazing. So these are the top 3 things that you should look out for from a legal perspective. But before you go ahead and buy that business, make sure to get professional heads of terms in place between you and the seller. And if you want to learn how to use heads of terms to your advantage, make sure to watch this video right here. Watch it now.